All right. Good morning, everyone, or good evening, good afternoon, depending on where you are. My name is Dian Shah, and I'm an assistant prof at the National University of Singapore, Faculty of Law. And along with my colleague, Arif Jamal, we are co-conveners of the CAL's Law and Religion cluster. Now, this cluster is part of a set of 4 academic and research clusters at CALS, and the other clusters are on comparative civil law traditions, comparative commercial law, and comparative public law. And all these clusters seek to provide spaces that facilitate discussion, debates, and sharing of ideas in their various fields and areas with a distinct focus on developments in Asia. So for the law and religion cluster, we're interested particularly in religious law, state-religion relations, and the regulation of religion and religious freedom. We embrace a contextual and multidisciplinary approach to understanding the dynamics between law and religion. Now, to this end, the cluster has organized a series of activities in the past, including the Distinguished Lecture Series, academic conferences, and of course, the Law and Religion Speaker Series, which you are part of today. So we typically run our speaker series talks in person. However, today we are grateful to have Dr. Gilad Abiri from Yale Law School joining us. Gilad is a Yale lecturer in law at Yale Law School, and he completed his LLM and JSD at the same institution. He is currently a global postdoctoral fellow at NYU Law School, Center for Law and Philosophy. Gilad's work span the areas of constitutional law, comparative constitutional law, focusing on law and religion, and constitutional and political theory. So welcome, Gilad, and welcome to all of you. Gilad, thank you again for being part of our speaker series. For our participants, we have the Q&A box in which you can use to pose your questions as we go along. And then after Gilad's presentation, we will deal with those questions and start the discussion. Gilad, you may take over the screen.
Thank you, Dian. So I'll just start by thanking the Center of Asian Legal Studies and Dian, Arif, and Jacqueline for inviting me to give this talk. In the last few times I came to NUS, it included a very, very long flight and excellent company and food on that aside. So I'll suffice with the company this time. And really thank you all for coming and listening. I really appreciate the engagement. So let me start. So one of the foundational questions in law and religion is whether we should treat religion as a distinct legal category, or more precisely, whether the fact that we treat religion as a distinct legal category is justified or not. And there are broadly 2, let's call it theoretical points of view here. The first is neutralism or neutrality, which is the position that the government, what the government is actually interested in, or should actually be interested in, is the non-distinctive and non-special qualities of religious entities. That is, if we want to protect people's deeply held beliefs, we should protect all deeply held beliefs, and religion is just one instance of that. This is the position that religious organizations and people are just no more distinctive or important than any analogous secular enterprises. So in contrast with that, we have a distinctivist paradigm. There are different names for it, but I'll call it distinctivist, which supports treating religious institutions as constitutionally special. They have different accounts to why religion actually merits the special disabilities and privileges thrust upon it in most constitutional regimes. So this distinctivist paradigm is has let's call it tremendous intuitive, textual, and historical weight in many constitutional regimes. In many constitutional texts, religion is mentioned without mention of conscience or culture, which are the competing categories. So the U.S. Constitution is obviously the very strong example of that. As far as I know, the Singaporean Constitution is also another one, where the text itself just mentions religion, religious freedom, or the separation of church and state as something about religion. Even in cases where you have a mention of conscience and religion in the same clause, such as the European Human Rights Accord, for example. Even then, if you look at the jurisprudence, as far as I know, as far as I understand, you will find that it's protected in different ways, de facto, if not de jure. However, if you turn to the realm of kind of scholarly debate in academia, the tables are turned completely, let's call it, right? So you have a neutralism completely dominate the debate. The idea that religion should not be singled out is the clear winner of the scholarly debate. So, and in fact, this conversation, I think, very much sounds like a broken record, and a loud broken record. First, someone comes up with some new account of why religion is actually distinct. And then this argument is quite easily refuted through some counterexamples that show that religion really is not unique, but rather just another form of strongly held belief or culture. So that's kind of like the layout of what's the problem that I'm trying to address in this talk. And I'm going to divide it into two halves broadly. One negative, in which I will try and describe why I think distinctivist accounts fail. Commonly, I think they fail because of the same reason usually. And then I'll turn to the second half, which is more positive, where I try to offer an alternative path towards this distinctivist account that actually makes sense and does not fall into this pitfall of why do we treat religions in special ways. And I want to just, before I start, I want to say something about the genre of the paper or the genre of this talk, which is based on two papers. And it's basically what more a political and legal theory argument rather than something that is integrated within a constitutional argument. So I think the political and moral theory and legal theory argument that I'm going to make has constitutional ramifications, but it's not embedded within the point of view of constitutional law from the get-go. So that's just why you're going to not hear a lot of constitutional law, and you're going to hear a lot of kind of abstract arguments. I think it also works because I actually am embedded in the US debate and a little bit in the Israeli debate, and I'm not well aware enough or educated enough in what's going on in other countries. So I think making a general argument makes more sense for this presentation. Okay, so I'll start with why I think distinctivist justifications fail. So in short, my argument is that we've been approaching this problem with the wrong conceptual tools. Specifically, I want to suggest that principle-based approaches, and I'll say what I mean by that in a second, fail almost necessarily when it comes to justifying the special status of religion. And I'll now take you very briefly through two of the main examples of such distinctivist accounts. And in the end, I'll say why I think they commonly fail, meaning I'll describe why I think these two specifically fail, and then I'll say why I think it's a common failure. So the first one is that religion is a special case of conscience, basically. The basic premise is that religious beliefs are deep constitutive convictions or beliefs, and making someone act against her religious faith is the same as forcing her to act against her conscience, against the very ideas and values that are at the core of who she is. And as I said, these two concepts are often so closely affiliated that they're collapsed into one another. So the European Convention of Human Rights protects, and I quote, the freedom of thought, conscience, and religion as one. So that's clearly, they're very close concepts in the minds of many people. So if we take this conscience point of view, why should religious conscience be singled out from other types of conscience is the question. How under such a principle can we find the privileging of religious freedom morally compelling in any way? And I think the only way is to argue that religious beliefs are special in some relevant way or distinct in some relevant way from other strongly held beliefs. So I'll just mention one common argument. There are several, but one of the common arguments is that religious beliefs are experienced or perceived by the believer, by the religious adherent, as being imposed externally upon them from a divine source. And this is, in these accounts, this contrasts with more secular forms of belief or morality, which are seen as a part of their internal processes and therefore slightly more of a matter of choice. So if it's something about your internal processes, it's as if you can be, meaning imposing upon you is less harmful to you in some way. So that's kind of like the argument you commonly hear, at least in the US context. The issue is that if you can plausibly find even one non-religious belief that is experienced as imposed externally, then this argument just does not justify the special status of religion. It immediately transforms into a neutral argument. And I think it does fail in both directions. Many modern religious adherents see their religion as very much a matter of choice, a part of their autonomy. And at the same time, many secular experiences of justice and morality are perceived as utterly beyond individual choice. The idea of the moral good can be as external and outside the realm of human choice as any norm dictated by God. So that's number one. That's conscience-based distinctivism and its failure. So now let me turn to the second candidate, which is culture-based distinctivism. The idea of cultural accommodation is the basis of this kind of argument, and it's premised on the understanding that human beings operate through and are embedded in cultures. And the idea is that if a person is able to live her life only within a culture, any meaningful autonomy or life choices that he or she can make require there to have like meaningful cultural options within society. So Joseph Raz is the famous phraser of this theory. He says that the ability of individuals to become authors of their own lives depends on the maintenance of a variety of attractive cultural options within a society, and diversity is thus a prerequisite for meaningful human autonomy. So that's basically how you culture justifies religious freedom, not distinctively, but just as a matter of having it. So it is possible to argue that religion is a culture that is especially demanding of its adherents. One can parallel the argument that religious beliefs are a unique form of conscience with the notion that religious cultures are an exceptionally intense form of encompassing culture. This claim can be grounded in the idea that religious groups produce especially thick norms, or that they're potentially more vulnerable to the secular mainstream in some way. However, it's actually very hard to maintain. And all of these attributes are prevalent in other ethnic, national, and indigenous minorities and communities. And this is why generally people that advocate for the cultural accommodation of religious groups are kind of willing to settle on an over-inclusive justification. They're willing to say, yes, we have religious freedom, but what we actually mean is some sort of right to culture. And it's just a proxy of that. Under this prism of culture, religion is merely another form of some sort of encompassing grouping, deserving neither more nor less protection than any other minority group. So that's number two, that's a cultural distinctivism and its failure. So now let me turn to say something general about principled approaches and why they fail in this specific project. A principled approach seeks to deduce this specialness of religion from some principle of morality or justice. And since we have a sense that moral principles apply equally to all individuals and groups, it follows that the only way to justify the special treatment of religion is to find that the religion is empirically distinct in some relevant way. And for this reason, all principled accounts necessarily find themselves arguing that some unique attribute of religion justifies its special status. And I think, and we can talk more about this, but that this type of argument is just doomed to fail, because religion, as we commonly recognize it, seems to have, at least conceptually, no unique attributes, and certainly not ones that justify singling it out from other forms of belief and culture. While we may be able to recognize religious groups as institutional and historical entities within a particular society, so we can understand what the Catholic Church is as an organization, and who are its members or people who go to church, it's actually extremely challenging to differentiate religion conceptually and theoretically from other candidates. So to sum up this negative part of the argument, principled arguments fail because they rely on the idea that religion is a singular phenomenon. That is, they seek to justify the special status enjoyed by religion by arguing that it is in fact special. And I think this makes them conceptually brittle, and produces this broken record dynamic in the scholarly debate, which I think is regrettable and we should try and avoid. So in order to avoid it, let me turn to my second half, which is the kind of like trying to open a path towards justifying the state of affairs, the status quo, with religion. And I want to suggest that the way to do this is from shifting theoretical modes, basically, from this mode of principles and trying to achieve justification through finding the principle that fits religion, which then leads you to this kind of like empirical black hole, to one that is to kind of like accounts that are based on agreements or social compromises, political compromises. And if we do that, I think we actually avoid the distinctiveness roadblock. And let me, I'll basically say first how we avoid it, and then try and show that it still has some sort of moral effect. That the idea of a political compromise, that the idea of the special status of religion as being based on a political compromise can have a significant moral effect. It can justify, under certain circumstances, the status quo. So in order to make it more concrete and not just kind of like constantly refer to a hypothetical compromise, I'll use a specific example. So Richard Rorty has quite a kind of like an infamous essay, Religion as a Conversation Stopper, it's called. And there he describes the special status of religion in the US context under the First Amendment as being a result of a Jeffersonian compromise in which religious adherents agree to the privatization of religion, meaning the non-establishment or the separation of church and state, for an exchange basically for religious freedom. So the two halves of the First Amendment, non-establishment is being exchanged for being traded for free exercise. That's under his conception. And why does he think that this compromise is a good thing? Because he thinks religion is a conversation stopper. And by this, he means that religious arguments work from assumptions that are not shared by everyone, and that therefore are inappropriate for democratic deliberation in deeply pluralist societies. Now, I do not want to defend this position. I don't hold this position, but it's kind of like a simple compromise account that is not mine, and therefore I can apply my ideas to. And I'll just say here, I think that it's important to understand the type of argument that I'm going to try and make, which is I'm not going to provide a specific compromise account and defend that. I am going to describe how a compromise account resolves the special status of religion question. So therefore, it's kind of like a meta argument. I'm going to deliver a structure that if you go through the structure, then you can justify a compromise account. I'm not here in this kind of talk interested in providing a specific compromise account, especially because I don't think there is a general one. I think different societies actually have different compromises. And those compromises under certain circumstances that we'll talk about in a second can have some justificatory effect on the status quo. Okay, so let me now talk about why I think compromise-based accounts actually resolve this issue. So most, or if not all, of what we have common distinctiveness accounts attempt to necessitate a specific legal regime according to a moral principle. If the principle is correct, then the legal distinctiveness of religion is necessary and morally justified. So this, in contrast to that, compromise-based justifications see the legal distinctiveness of religion as morally acceptable and not necessary. So it does not become necessary because of some sort of moral compromise. It becomes necessary because there is a political agreement, some sort of social political compromise that we believe or the sides believe promote peace, stability, or some other political goods. And the compromise is justified because it produces those goods and because the sides consented to it, rather than because it is a result of some sort of specific principle that points specifically to this legal regime. So crucially, the advantage of a compromise justification is that it is based on an agreement and not principle. An agreement changes the moral obligations, the political, moral, financial obligations of the sides of the agreement, and does not change everyone's moral obligations like a principle is supposed to. A compromise is based on a specific tension between the sides and on the fact that the sides consent to resolve the tension. If the distinctiveness of religion is based on a compromise between non-religious and religious individuals, or between the state and religious groups, it does not follow that the same kind of agreement must be offered to all entities that share some or all of the attributes of religion. So just an example from another sphere, take two states that agree to exchange territory to resolve some sort of political tension. The fact that a third state is identical in all its characteristics to those entering the agreement has no impact on the relevance. It's irrelevant to the obligations that arise from the agreement itself. Only those who have had a conflicted relationship and agreed to give up things that they want in order to reach a compromise receive moral rights and obligations as a part of the agreement. And I think this different normative operation is a result of the fact that principal justifications and political compromises aim at very different goals. Principal justifications seek to reach a just regime, and compromises seek to produce some sort of peace. And it's important to understand that, at least in this, to kind of like comprehend the idea of a compromise, of a political compromise, is that there is a trade-off here. Arguing that the legal institution is justified according to a political compromise is the same as saying that we're willing to sacrifice some justice to achieve peace. And the opposite is also true. If we stick to our guns to establish a perfectly just legal regime, which seems to be the assumption of a lot of these principled accounts, we are willing to give up some peace for it. And just let me give the example of religious freedom. In many cases, the behavior of religious groups and institutions is a direct affront to liberal conceptions of justice. I think that's anyone who studies law and religion knows this. And it's enough to just mention the unequal treatment of women that is common in many major religions. And now let me assume a few things. Let me assume that this behavior is strictly unjustifiable and that there is no good justice-based argument for allowing religious institutions to discriminate against women. And let me also assume that stopping this discriminatory practice will involve some civil unrest. I think both of those assumptions are plausible. In such a case, it's clear that the state or the government or the people running it have a trade-off of justice and peace. You can either have justice or you can have more social peace, and the more you have this, the less you have that, and it's just a trade-off. So in this case, the political compromise between religion and state, the point of the argument is that it justifies a somewhat unjust state of affairs because it promotes peace. So therefore, if you want to single out religion in a way that is somewhat unjust, and we're going to talk about what that means in a second, it can be justified. That's the point of political compromises. Okay, but if it resolves one problem, the problem of religion not having special attributes, it raises its own set of challenges to establish a political compromise. The main one is, how do we establish consent to such collective and transtemporal issues as the constitutional regulation of religion? So in my work, I try to resolve this issue by turning to a body of work, contractarian theory, which and I'm not going to go way into it now, but in the broadest lines possible, this is the position that norms derive their authority from the existence of mutual agreements or contracts. Now, many contractarian theories have this challenge of establishing tacit consent in the absence of clearly defined sides and signed documents. And I'll say something about the two types of main contracts. So the main body of contractarian theories is what we call social contract theories. And those try to establish all of morality or all of political authority and legitimacy on the idea of contract. That's one type. Then another type is contractarian theories that try to justify specific legal regimes as a result of conventions or compromise. And this project is trying to be more of the latter. So I'm trying to say that this particular area of law, the special treatment of religion, is a matter of, is a place where we can find this idea of a political compromise as useful. I'm agnostic about whether everything is like this or not. This is not the goal here. So they have a tool set of how we try and get to this tacit consent. And I've, in my work, offered 3 principles which a compromise should fulfill or must fulfill in order to become morally effective or justified. And I will go through them quite quickly. These are the principle of actuality, meaning the political compromise should be the actual social and legal practice. The principle of the criteria of mutual benefit. We need to have an understanding of how this benefits both sides, not only one side, because one side it can be just imposed or just coerced. And the more complicated one, or is the criteria of fairness, or some minimal moral threshold that a compromise must surpass in order to be morally effective. So I'll go one by one. So first, in order for us to be able to presume consent in the case of a social rule, it must be actually followed. Meaning the fact that it's actually followed is strong evidence that there is acceptance or consent. And this condition broadly relies on H.L.A. Hart's concept of the attitude of acceptance towards social rules. And in his work, individuals exhibit acceptance of a rule when they adopt it as a guide to their future conduct and as a criteria of criticism of other people's conduct. These individuals take the internal point of view towards these rules. Now, his is more of a descriptive thing, but this type of contradictarian theory normatively charges this Hartian concept of acceptance. And if a rule is habitually obeyed and mutually beneficial and fair, then we can view the attitude of acceptance as a sign of binding agreement. So let me just apply it to Rorty's account of the First Amendment. These kind of like the First Amendment, both sides of it are clearly habitually obeyed. There is a strong norm of religious freedom in the US, and there is a strong norm of separation of church and state. And I think that's broadly true for most constitutional regimes in the world. So the habitual obeyed part of it is not a real challenge to this account. So let me turn to the criteria. The second criteria, mutual benefit. While habitual obedience shows that a social practice is followed, it does not suffice on its own to show consent. The reason is simple, is that we can easily think of social practices that are imposed upon society rather than being a result of some sort of agreement or acceptance. Therefore, to establish that a habitually obeyed rule is part of a contract, we need to be able to see it as mutually beneficial in some way. And that is, we need to identify the motivation of the sides to enter the contract freely. So the idea of the compromise here is a variation. A compromise means that there is a conflict and that the new situation resolves this conflict. So part of the mutual benefit is the resolution of the conflict itself. And in order for it to make sense, we need to have a sense in which the current regime that is actually obeyed actually resolves the conflict. And this really depends on what theory of conflict you bring into this. But let's again apply it to Rory's idea. He has a sense in which democracies can only flourish if religion is excluded from the public sphere. That's the need of non-religious people or of the state or of democracy, of getting religion out of the public sphere. And and religious believers have a strong need of not being imposed upon by the state when it contradicts their religious beliefs. And they get that. And this exchange basically allows both sides to continually exist in society together relatively peacefully, according to him. So that means that under his account, we have a mutual benefit. Now let me turn to the third criteria, which is fairness, or a minimal moral threshold. This is much more complicated, and I think whatever I'm going to say is going to be insufficient to really get to the bottom of it, but I'll say something. So some agreement and compromises are just rotten and abhorrent, and therefore I think they should be morally ineffective no matter whether you can find consent to them or not. So one example is perhaps one of the more famous examples of a clear political compromise that was abhorrent is the U.S. Constitution before the Civil War, or after the Civil War until civil rights, which encapsulated an abhorrent compromise on the issue of slavery. So it was an actual compromise. It did actually produce some peace for some period of time, but in my account, it fails the minimal moral threshold. Again, you can argue about this, and people do argue about it, but I just want to give an example of what is a rotten compromise for me. So this kind of like shows that the moral effectiveness of a political compromise is limited by some sort of pre-contractual morality. And this can be arising from all sorts of different theories of morality, but there is some sort of limit to it. So the question is, then, what makes a regime of law and religion sufficiently good? And again, since the political compromise justifies because of peace, there is a strong reason to put this threshold quite minimally, meaning to develop the moral threshold criteria as quite a minimal one, because you want more peace in society. So I'm going to describe it quite a minimal threshold. So one of the kind of problematic facts that we have here is that the liberal regimes of law and religion vary dramatically from one another. And our intuition needs to make sense of that. So you have some countries, such as the United Kingdom and many of the Scandinavian countries, for example, that have an established church, and we still consider them good constitutional democracies. Others subsidize and support some religions while not supporting others. So in Canada, the province of Ontario funds Catholic schools and does not fund in the same way other religious schools. Others, such as France and the United States, have very strong forms of non-establishment. And all of these exist within what I think intuitively we think of as decent societies, decent constitutional regimes. So my minimal threshold is basically designed to exclude societies that are not members of this club intuitively. And I'll think that I suggest that the distinctive treatment of religion is fair if it satisfies the following two propositions. First, any liberal compromise must include a minimal measure of religious freedom. And therefore, the policies of countries that seek to overwhelm religion out of existence cannot be justified as liberal compromises. And just think of the historical relationship of the Soviet Union or the current relationship of North Korea to religion to make this kind of like an evident point. Since the minimal measure of religious freedom, not the distinctiveness of it, but just the freedom itself, is justified as a part of other freedoms such as conscience and culture, outright antagonism toward religion is not consonant with liberal compromises. And the second criteria is that this minimal measure of religious freedom needs to apply to religion as a general category and cannot be limited to one religious group. So we can imagine regimes in which one group of people has religious freedom and the rest are persecuted at the same time. And that doesn't work with this second criteria. Now, I want to be clear that this does not mean that all the aspects of any particular compromise, if you apply it to a particular regime, must apply equally to all religious groups. So as I said, take the Church of England, for example, you have very strong norms of religious freedom in the UK that apply generally to all religious groups, but at the same time, you have an established church. So under my account, under these two criteria, that can fly, meaning that can be justified as a political compromise that works. So again, if we go back to Rorty, does the US First Amendment pass this threshold? Easily it does. There is a minimal level of religious freedom. There's a lot of religious freedom, and it does apply generally, perhaps too generally in the US. So it passes this. So that means that if we accept Rorty's assumptions and arguments, which we don't have to. But if we do, then we have an account that resolves the issue of the special status of religion satisfactorily, because it's a part of an agreement and not a part of a principled approach. So now, before I conclude my talk very briefly, I want to say something about the open nature of what I just described to you. What I was trying to show in this talk is not that a particular account of compromise works best and can justify the special treatment of religion in every constitutional regime. That was not the point. My point was that this is a path towards having a more fruitful debate about these things, I think, than the one that is now had, at least in the literature that I'm well aware of. And that is, we need to examine each particular place in each particular country and try and understand how the compromise that exists already in those countries, whether it works or not work under this kind of structure that I just laid out. If it does, then good. We can have the debate in a way that is more respectful of the history and particular political circumstances of particular places, and still have it in a way that is normatively satisfactory. So a lot of the debate that you have now, at least, is that you have people that are within the system take the internal point of view of the constitutional law of that specific regime, and they just assume that the distinctiveness of religion is something that makes sense. So we have a history of, I don't know, the Puritans ran away from England to the US and started a city upon a hill, and that city historically justifies the strong protections on religion in the US. That's not bad, but it needs a second step. And what I wanted to suggest here in this talk is to do the work of this second step, to bring us from this kind of historical argument into legal and political theory. So now let me conclude. Should we treat religion as a distinct legal category? Should we privilege and constrain it in ways that do not apply to other forms of belief and culture? If we continue to debate this question using the tools of principled legal and political theory, I think the answer is most likely no. It would make much more sense to establish constitutional, conscious, and cultural protections than to surrender unjustly to the historical, textual, and intuitive clout of religion. However, as I suggested in this talk, the political compromise approach opens a path for us to justify the special status of religion while being sensitive to particular histories, texts, and popular intuition. And I think I'll stop here, and I want to thank everyone for their attention. I'm sure it's not easy to listen to this talk on Zoom. Thank you.
Thank you very much, Gilad. A very fascinating and heavy account that you have presented there, and certainly that has got my brain up and running in the morning here in Singapore. So thank you again for that. We'll open for question and answer session now, and for further discussion to interrogate some of the ideas presented by Gilad in his talk. So while we wait for more questions, we have two now in the question and answer box. From Jianlin, has there ever been an era where principled justification of religion's distinctiveness can be sustained?
Yeah, so I think that's an interesting question. And I think perhaps the answer is meaning I think it's possible. But it would require a very particular society in which you would not have. So the problem with principled account is that you have counterexamples, basically, and that you rely on some sort of empirical reality that just is very hard to establish in any society plausibly. So again, I'm not a historian, but it is possible that you have a society in which religion is actually a completely distinct thing, where the historical reality is that you don't have other circumstances. For example, societies that are completely religious, for example. That's possible that there you would have a place that is this. I did not read your elaboration rationale of question, Dian, but I hope that answers a little bit.
We are still open for questions if the participants have any. If they don't, I'm going to pose a question in the meantime, Gilad. So I was wondering about your political compromise account. And I was wondering if you think that power dynamics are crucial in shaping compromise, or the extent of the compromise. And if so, what do you think the implications are?
Yeah, that's a very, very good question. And I think certainly power dynamics. So the way I see it, I don't know if I'll give a historical example from my homeland, Israel. So when you have a process of establishing the country, or of creating the constitution, there is no constitution, but of constitutionalizing the country. It's a form of power negotiations, or a negotiation that takes account the different powers of societies. And the idea is to see that not only as a development of a modus vivendi, basically of saying, okay, religious groups, you're now X powerful, and because of that, we're going to give you religious freedom. But whenever your power diminishes or increases, we're going to change that. The idea of a compromise, at least as I tried to conceptualize it here, is that there is this agreement itself, this constitutionalizing of the compromise, has normative weight in itself. So it obligates both sides as long as they maintain the compromise. So the interesting question is what happens when one side breaks the compromise, and it happens. So one of the realms where I think it happens, and I wrote about this before, is the challenge of religious nationalism. So where you have a group that accepted, often what happens is that they were not powerful enough in the establishment of the state, but they never accepted the compromise. And when they became more and more powerful because of social and historical reasons, they just don't accept it. What happens towards them? Does religious freedom apply to them? That's kind of like an open question, but it definitely arises from this idea of a compromise, of what happens when this compromise is broken. It can also be broken by the state, obviously. So you have completely secularized societies which all of a sudden don't understand why do we need to allow this, and that's also a breaking of the compromise, I think, and changes the norms that apply under this account. But this depends particularly on where you're looking at, and it needs to be examined more ad hoc.
Thank you, Gilad. So before we go to Arif's questions, he has two questions in the chat box. Charisse has refined her question. She says that what she really means is whether there will ever be a state where religion and constitution are in the same playing field.
Oh, that's very interesting. Yeah, so I think it's hypothetically possible, meaning you can have a place where religion is liberal, right? It wants to have liberal norms, and that is kind of, but that it's not exactly a compromise then, right? You would have just an agreement, just a cooperation. I think again, it is possible. We have countries. We know this that are incredibly religious and have some sort of effective constitutional law. It's kind of like Ron Herschel's book is basically about that, about how you have religious regimes in which constitutional law is still somewhat effective, and a part of that is because of religious adherence, or kind of like religious leaders supporting it. So I hope that answers the question. Yeah.
Thank you again, Gilad. Two questions from Arif. First, how would your compromise paradigm face the issue of shifting demographics, especially religious demographics? Would we need shifting compromises? And secondly, might we not see the Jeffersonian compromise differently, i.e. based on a principle namely classical liberal theory of neutrality?
Yeah, so the shifting compromise thing I think is very interesting, and I think the way I was trying to describe it, I wanted to have this agreement or this compromise have holding power. Basically saying not whenever. So that's why, at least in the papers, I try to distinguish it from a modus vivendi. The modus vivendi, the moment you have a shifting of demographics, the challenge changes. But let's say, so you have religious freedom norms in Europe. You have a huge demographic shift there. The religion is different all of a sudden. So the question is whether it applies or not. I think in these societies where, yeah, I think the compromise holds, but seems to me to need adjustment, not only on religion, but generally these societies are so dramatically transformed that they at some point just need to rethink what's going on constitutionally there, whether religious freedom is still justified under those regimes as it applies to new religious groups. I think the answer is yes. As I said, there is a minimal level of religious freedom that must apply to everyone because it's not justified because of this compromise. Now, can you tell me the second question again?
The second question is, might we not see the Jeffersonian compromise differently, i.e. as based on a principle, namely classical liberal theory of neutrality?
So we can certainly see it as a matter of principle. But the question is, how does this principle then justify treating religion particularly? Well, you can, again, neutrality just says we're neutral. If I understand what you mean, Arif, we're just neutral towards conceptions of the good, for example. Conception of the good is not necessarily religious. We just keep out of it. The state keeps out. So neutrality just doesn't justify the distinctiveness of religion unless you put on top of it the idea of compromise and agreement, which then perhaps it does the work. I hope that's what you meant, Arif, but I'm not sure.
Okay, a further question by Candy Gunn. And her question, I think, straddles the field of, or the issue of legal pluralism as well. Yeah. You know, for countries like Jordan, who for a dispute resolution allow for tribal laws to govern established tribes and only step in when the state's overarching jurisdiction if the tribal laws cannot solve the dispute. What do you think about that, Gilad?
So I'm not going to say anything specific about Jordan. I don't know it well enough. But I will say that, again, the project is to try and say, why are these norms justified within the context of liberal constitutional law? So wherever you think that applies, that's the aim of the project. That's the subject of the project. There are just regimes that have compromises. There are many compromises with religions that are just don't go into that box. You can have a perfectly, I don't know what Rawls called decent society where, you know, people live normal lives and have good lives, and there is a compromise with religion that allows tribal laws that, again, I don't know these tribal laws specifically, but are perhaps not liberal to exist in a way that is not justified as a part of my political compromise account. So legal pluralism or religious pluralism, or kind of like legal religious pluralism, up to what I said, minimal fairness or minimal threshold of morality. And again, that level of morality needs to be debated. And I just offered something tentative there. That's not the main point of what I was trying to say. But the project is there needs to be some sort of line between where we think are justifiable, good constitutional regimes and where we think they're not there, which doesn't mean that they're evil or abhorrent, but they're just not the project of trying to justify this.
And as a follow-up question, she also asks, how do you view countries that might face differing treatments of citizens versus tribe members who follow different legal systems?
Yeah, so I think basically the same answer would work here also. This idea of equality before the law is a basic premise here also, and it's only the special treatment of religion justifies some differentiation from that principle, but not extensive, not all the way, not having actually completely different legal regimes under one state.
Okay. And next question from Sharda from India. And Sharda wants to know about the position of law and religion in respect to conversion of religion by force.
I think,
yeah,
I think we're against it.
Okay, very short and sweet response to that. From Jingmin Tan, what happens when the political compromise that you're advocating on religious freedom clashes with other aspects of social contract in a liberal constitution?
Yeah, a religious group claims that religious feelings are offended. Yeah. So again, I think that's an application question of where I think it really depends on the form of the compromise. It's again, the idea here is that the political compromise justifies some things that are unjust, not extremely unjust, not extremely unfair, but some things that are unjust. And I gave the example of this kind of like discrimination against women, which is one of the things that are allowed to a degree in all liberal regimes that I know. No one is telling the Catholic Church you need to ordain women. No regimes that I know says that. Again, it's offensive perhaps, but it's not something that anyone tries to impose on them. And again, so the question is, what is the interest group's expression of political opinion? Kind of like emotions, and it really depends on the particular compromise. Different regimes have different norms on this, and I don't think the political compromise has any traction on this specific question.
And a question from Ahmad Rofi, which I think speaks to some aspects of Jin Ming's question too. Can the state's establishment of religious law, for instance, Islamic law, be justified under the liberal constitutionalism paradigm, or can it be consistent with the ideal of religious freedom?
Yeah, that's a very good question. So I gave the example, like an easy example, right, which is England or Sweden or one of these countries that have an established regime. But let's take a harder example, Israel. So Israel does have a legislation of Jewish law and Islamic law, and it depends on what regime. Can that be justified by liberal constitutionalism? So I'll just say I think it's a very good question, and I don't have a very good answer. I think it largely depends on the details, how decently other religious groups are treated, for example, how decently citizens generally are treated, and it's kind of very hard for me to answer this in the abstract. But generally, my tendency would be to say you would need to you can have some religious law while still maintaining liberalism, but the exact measure is hard to kind of like figure out.
Any further questions from our participants? We still have a bit of time, so if there are further questions, please post them into the chat box, the Q&A box. If not, or while we wait for hopefully one or two more, let me pick your brain a little bit, Gilad, on some of the issues that you raised. Now, when you talked about the different paradigms on the treatment of religion, I wonder if you take religion to mean the orthodox belief systems, kind of the main religions of the world, or do you conceptualize religion as a broad umbrella that could include belief systems, no matter how alien, for a lack of a better word, or unfamiliar they are to those who subscribe to the more orthodox or major religions of the world? And
yeah,
the reason, And the reason why I ask this is because in Asia, for instance, there are traditional belief systems outside of the main religions of the world, and there have been struggles in getting their customs, traditions, and practices recognized and protected. So there are real practical implications of these struggles, for instance, where states refuse to protect and recognize these belief systems, and that means that they could not register marriages, they could not register births, and therefore then they have problems in accessing public resources such as healthcare and so on. So in such cases, here I'm playing devil's advocate a bit, perhaps one can understand at least the distinctiveness paradigm or the appeal of the distinctiveness paradigm in protecting religion or belief systems, as deserving special protection because, these are intricately connected to one's thought and conscience and also one's deeply ingrained and deeply held customs and traditions.
Yeah. No, so that's a wonderful question. So two things, just on the top of my head. So the first thing is, because my account focuses on a political compromise, it has a tendency to kind of like be a realpolitik type of account, and because of that, it focuses on major religious groups.
Okay.
So in Israel, Judaism, Islam; in the US, Christianity. Those are the instigators of the compromise.
Yeah.
However, and this is a second thing. First of all, as I said, we need to kind of debate how to fill in the fairness requirement of this. So it can, some sort of minimal, and what is the minimal religious freedom that applies? So that a solution can go into that. And the second thing is, and in this I'm a bit influenced by the American doctrine, is that although I think the compromise is actually with Christianity, I think it's very good for the state to not have a say in defining religion very strongly. So in that case, it's not as if the state has a political compromise with the Amish in the US. They're insignificant politically. They're very significant culturally, but they're insignificant politically. It's better for the state to not make these lines between the Amish and the evangelical Christians and the Catholics and the Jews and the Muslims and the Hindus, and all the pizza churches that they have that come up and get, and in the US get religious freedom. So I like that approach in the US, and but again, it's not inferred from the political compromise account. This needs further thought, whether there is any traction on this at all. But yeah.
Thank you, Gilad. Final question perhaps from Bo. He has a few things to say there. I'll just read it out for the benefit of our participants here. Isn't the problem with the distinctiveness account that liberal theory rules out a main historical and current reason religion is distinctive? This or that religion is powerful, wealthy, organized social force that could inspire mobilized resistance if not accommodated. Now, if you allow that reason as a principle of distinction, then can your proposal, Gilad, be considered as a principle, though maybe he thinks, both things, illiberal in current forms, but arguably Republican approach, especially considering, as you point out, that maintaining peace and order is a valid constitutional goal?
Yeah, so Bo, thank you very much. I think that's a good question. Yes, meaning a part of the idea here is to try and bring the game from historical accounts to theoretical accounts. That's kind of like the project of this political compromise account, of saying, okay, so now let's read Bo's interesting book about the Philippine constitutional history and think about what are the normative implications of that in a way that doesn't just, okay, now we have two principles of justice and let's apply those two principles of justice, which is a worthwhile exercise to do. But in the Philippines, the history of religion is different, and it has different political circumstances. And as you said, powerful, wealthy, organized social force, etc. And it just changes the circumstances. And we must be able to say that shifts what is a legitimate constitutional regime in a place like the Philippines. Not that I know a lot about the Philippines, I'm just giving an example because it's you, Bo. So yeah, and I hope that answers. So I'm fine with you calling it the principled account, in the sense that it's trying to get from history to a normative theory. So a normative theory has some sort of, so again, you can say, why are you putting so much weight on the idea of consent? Why is consent doing work? That's a principle. But it's a non-problematic principle in the sense that it doesn't make me go immediately and try and say, oh, what's connecting Hinduism and Buddhism and Christianity and Judaism and all these other religions, and what distinguishes that huge group of human cultures and beliefs from another huge group of human cultures and beliefs that are non-religious. So I can with if I get to a level of principled theory that doesn't make me do that, then that's the level where I want to be, and I think it's possible to frame it in that way. So thank you.
Alrighty, it doesn't look like we have any further questions, and I know it's very late in your side of the world, Gilad, so I'm happy to let you go, and we can of course continue the conversation via email or with future discussions through the speaker series. We have one more speaker series scheduled for this year. So let me thank you again, Gilad, for a wonderful presentation, a lot to think about.
Thank you very much, Dan.
All right, everyone, thank you for joining us, and we will be updating you on the next speaker series, hopefully sometime in November. Thank you again for joining us and for your participation. We look forward to seeing you again online soon. Have a good day, everyone. Bye.